appeal.
So how is it preserved?
Yes, it is preserved because it is a purely legal issue arising on undisputed facts.
Well, is that true, though? Because were you in front of the same district court judge?
I believe this was all Judge Waller, Your Honor.
And so if it's the same district court judge, how is it purely a question of law when what you're asking for is for it to be sent back to Judge Waller?
Well, to be sent back to whoever would decide that case.
You see my point, though.
He's no longer on the bench, if that makes any difference.
The point being, how is it purely a question of law when at the motion to correct an illegal sentence, you were in front of the same judge that handled the probation revocation hearing? So in other words, shouldn't you have raised that argument then when you're in front of that same judge?
Well, Your Honor, maybe it should have been raised.
Because it's a factual question as to what was in that district court judge's head when he was rendering his decision on the revocation.
Your Honor, I guess the best way to answer that question is, for me, the way I view this is that the state filed a motion to correct the initial illegal sentence. So that's what the district court
I'm just trying to figure out why this is preserved. If you conceded that you didn't make this argument to the district court below.
Your Honor, I think it's preserved because it's a purely legal question of whether we need to go back. It's a purely legal question of whether the judge at the PV hearing was exercising his discretion about whether to impose something less than lifetime. Because I think...
Isn't that a fact question?
Well, I don't think it is, Your Honor. A judge at a probation revocation hearing has no legal authority to give a sentence which is higher than the one underlying probation.
The whole point is we don't know from the record what the district court judge was doing.
We don't know whether the authority was exercised. The reason you think it's a legal question is you think the mere existence of the opportunity means that that's what happened, that the authority to do something lesser was exercised. And we're saying, we don't know. Do you understand why to us, it looks like a fact question, whereas to you, necessary to your argument, it's a legal question. Does that make sense?
I think I do understand, Your Honor. And I guess my response to that is, when you look at the actual PV hearing, the judge had absolutely no authority to give a lifetime post-release sentence. To do that, he would have to correct the underlying sentence first. Because by statute, you cannot give a sentence as a probation revocation sentence that's greater than the underlying sentence.
But he certainly had authority at that moment to correct it if he had appreciated there was a problem.
Well, certainly.
Because you can do that at any time, any court, at the prompting or not at the prompting of a party, right? It's kind of like jurisdiction. Yeah. It's sort of the evergreen argument, right?
Well, I'm not sure
That may have been too obscure of an analogy, but the bottom line is anybody can make an argument at any time, including the court sua sponte, that a sentence is illegal and it needs to be corrected.
Yeah, absolutely, okay. Your Honor.
So Judge Waller had that power at the PV hearing had he realized there was a problem.
Yes, Your Honor, and it didn't happen. And I guess my argument is because it didn't happen, there was no authority at the PV hearing to give anything greater than 24.
It's not an absence of authority, it's an absence of an exercise of authority.
Well, his exercise of authority is contingent upon first correcting the sentence. I understand your point, Your Honor.
I think that's where we have the factual legal disconnect, is that you're making an as a matter of law because the opportunity existed, it in fact happened. And we're saying, not so much. Do you get that?
I think I understand your point, Your Honor.
Okay, thanks.
Any further questions? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement. Turn to the fourth case on this morning's docket, case number 113753, State v. Roth.
May it please the Court, Sam Shire of the Kansas Appellate Defender Office, appearing on behalf of the defendant appellant, Andrew Roth. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is granted.
Thank you, Your Honor. To briefly restate the facts, back in 2008, Mr. Roth pled no contest to 1 count of aggravated sexual battery and 2 counts of aggravated burglary. At sentencing, the district court imposed probation with an underlying sentence of 102 months imprisonment, followed by 24 months of post-release supervision. That post-release aspect of that sentence was illegal. By statute, it was required to be lifetime. In 2010, the district court revoked Mr. Roth's probation and imposed a modified prison sentence of 51 months in prison, followed by 24 months of post-release supervision. Later still, in 2014, the district court was notified that Mr. Roth's initial 24-month post-release sentence was illegal. At the state's request, the district court modified that post-release sentence from a term of 24 months to a term of lifetime. Mr. Roth appealed. The Court of Appeals affirmed. We filed a petition for review, which this court granted, and that is how we got to where we are today.
And a different judge handled the motion to correct an illegal sentence, correct?
Correct, Your Honor.
And the rationale was the original judge really didn't even take a look at post-release, whether it was legal or not.
Yes, Your Honor. And obviously, this case is very similar to the previous case that was argued. The key distinctions in this case from the prior case is that, number one, we have here a district court explicitly stating that it was giving a modified sentence. And secondly, and possibly of greater or less consequence, I don't know, but we have a different judge ruling on the probation revocation rulings and the motion to correct illegal sentence.
Does it make a difference that when Judge Wirtz at the probation revocation hearing said, I'm imposing the mandated 24 months, indicating that he was under the misimpression that the law required 24 months as opposed to it requires lifetime and I'm going to give you a break and move it down to 24 months? The word mandated, it seems to me, indicates that the judge made a mistake of law.
Your Honor, I think that's a possible implication to draw from that statement. And I wouldn't dispute the fact that it's certainly possible that the PV judge in this case knew or was under the misimpression that the lifetime post-release sentence is illegal.
Well, you and I can agree that 24 months was not mandated at the probation revocation hearing. It was not a mandated 24-month post-release provision. It was mandated to be lifetime.
I would slightly, actually I do disagree, Your Honor. And that's because, again, until Mr. Roth's initial sentence is corrected, which it wasn't at the PV hearing, the district court had no authority to impose a lifetime post-release sentence as a probation revocation sentence. For this to happen, it would have had to have occurred in a sequential order of the sentence being corrected prior to the PV. Because at a PV, you can't give a sentence that's greater than what's currently underlying probation.
In other words, you're saying that it was mandated because it was ordered at sentencing.
Yes, Your Honor. But I think at the end of the day, there's no way, based on the record we have, to know with absolute certainty what the judge at the PV hearing was thinking. I would concede.
Does it matter, Counselor? If the judge was mistaken and thought the statutory period was 24 months, legally mistaken, but pronounces that anyway, is that a grounds for correcting an illegal sentence?
Well, I don't believe it is, Your Honor. And
That's McKnight, right?
That's
McKnight.
That's McKnight.
Yeah.
Correct. And the judge very clearly did state that he was giving a modified sentence. The prison sentence was reduced, so we know this isn't the exact same sentence that was given at initial sentencing. and that modified sentence is lawful. So I think that's simply what his sentence is, based upon the reasoning of Abasolo and McKnight. So that's the basic argument that we're making.
Do you have your second argument as well in this case? I mean, I think you do, right? That if you lose on your first issue, that you want to remand.
Well, that's not an issue that's raised in the brief or the petition for
Okay.
review.
And so that's just not on the table in this case.
Well, I mean, to the extent that this is an illegal sentence issue, this court can correct illegal sentences at any time. So if this court decides that the only way to correct this is to send it back down for a PV hearing, possibly.
Well, but
That
the
would be on the
sentence
table.
was already corrected, right?
Well, the initial sentence was corrected. That, in my view, that doesn't touch the PV sentence, which is what he's actually serving now. He's not serving the initial sentence, he's serving the PV sentence.
I guess I can ask your opposing counsel this, but your recitation of the facts below is that when the district court acted on the state's motion to correct, it only touched the original sentence. It did not touch the PV sentence.
That's my understanding of the. I don't think that was really. I'm not sure that this issue that we're talking about now was on anybody's mind at the motion to correct illegal sentence hearing. But I think by necessity, when the state is filing that motion to correct illegal sentence, it has to be moving to correct the illegal initial sentence, because at a PV hearing, that's, a term of 24 months isn't illegal. But Your Honor, that hasn't been in the petition or in the brief as a matter of candor.
But do we just know what happened? I guess we can check and see if we can figure it out. But I don't know, and so I'm asking you. Do you know what the district court actually did? In other words, in the pronouncement and journal entry on the motion to correct, what was it correcting?
I'd have to check on the PV journal entry whether the PV journal entry was corrected.
Okay. Yeah, that's my question, and you're just saying you don't know as you stand here. And
That's
I don't
correct,
know.
Your Honor.
Thank you.
Any more questions?
What I'm seeing here, I think I'm looking at the correct pre-hearing now, that Judge Frederick opined that no one, quote, no one asked Judge Worst to address the issue of post-release, end quote, and nothing suggests he was aware the period was wrong. And that appears to be the rationale for granting the motion to correct, is that the judge really didn't know it was illegal.
Right, Your Honor. I guess as I understood the district court's ruling, it was essentially that once it's corrected as an initial sentence, it just flows through the PV disposition. I guess that's how I understood the district court ruling.
Any more questions?
And just so if that is correct, then the district court granted the correction to both sentences, not just the underlying sentence.
Well, I suppose, and we're still within one case, even though
Right.
these are two sentences. I guess the only thing I would note, and I will absolutely concede that this was not the direction that the brief or the petition took, but since this is essentially an illegal sentence issue, I think this court may have more freedom than it would normally have to go outside the parameters of the briefing.
Any more questions? Thank you, counsel.
May it please the court, my name is Tamara Hicks, Assistant Finney County Attorney. In this particular case, we had several different assistant county attorneys dealing with the different stages of the proceeding, and we also had different district court judges for all of the proceedings. In the plea hearing, we had a different judge. In the probation violation, we had Judge Worst, and then for the motion to correct the illegal sentence, we had Judge Frederick. In the motion to correct, a legal sentence, as you indicated, Judge. Judge Frederick did rely on what Judge Wurst had said, or what he had done. He had given the same terms on the sentences, like he gave the same numbers in the box for each sentence, but determined that he should run them concurrent to each other versus consecutive. So the numbers were the same all the way through, just concurrent counts in that particular case. And he made that decision based on the fact that the violations of probation dealt with his addiction. There were everything that went wrong in his probation seemed to fall back on the fact that he was addicted to both meth and cocaine, and these violations occurred because of that. He had gotten some treatment, which he indicated was not successful, and the judge, in his determining to make it concurrent, argued or made his statement that he was doing it because there were no new crimes, and it appeared that this was a problem of addiction, but that he still felt that he had violated probation and should serve a term, just
And
not
the
as
only
lengthy.
the only portion of the original sentence that was changed to concurrent was the incarceration portion.
Correct. And then he indicated, his statement was, I'm announcing the mandated 24 months, which was what was in the original pre-sentence investigation, and all parties, including the original sentencing and the probation, were under the impression that that was the correct number of post-release, which at this point we know was not, and it was to be a lifetime post-release.
Would it have been legal if the judge had knowingly made the additional modification that I'm aware it should have been lifetime, but I'm going to make a 24-month post-release? Would that have been a legal disposition at the revocation hearing?
I think it would have been something that the state could have appealed on the probation revocation, but based on the fact that it is case law that says any lesser sentence is allowed, I guess he could have done that. But the state would have had an opportunity to raise that as being
Abuse of
improper.
discretion? It wouldn't have been an illegal sentence, is what you're saying.
Yes, that's what I'm
If
saying.
it's not an illegal sentence, then there's no way for you to prevail in this appeal, is there?
I believe that if the judge had said, I understand it's lifetime, but I'm not doing that, I think he could do that. But that's not what happened in this case. He merely said, you got 24 months on the original sentence, and I'm saying that you
Right,
still
so,
have...
so maybe there's an error there, but why does that error render the sentence illegal under our definition of an illegal sentence?
Because it was based on the error.
Because it was a mistake.
It
But
was a mistake.
illegal sentences are far narrower than sentences that contain errors.
And the reason that the state filed the motion to correct the illegal sentence is because we were advised through the Department of Corrections that we had
Right.
provided the wrong...
Weren't you out of time? I mean, wasn't that the only procedural mechanism left to you? Because you didn't file a direct appeal.
Right, we did not file a direct appeal.
I mean, and this court has even said that errors as significant as constitutional errors don't render a sentence illegal under our statutory definition. So I'm struggling with, based on the concessions or the statements you made earlier, that this sentence could have been imposed. I'm struggling with how is it illegal if it could have been imposed.
I think her
Which-
argument is that it wasn't. That's why it's illegal, is that it wasn't.
Because that's not what the judge
Did,
said. He
in
just
fact.
merely...
Why does it matter what he did? What matters, in other words, I guess my question is, why isn't it just the sentence that's pronounced that we look at? Why do we look behind that?
Because it was based on the illegal sentence originally given. And he did not modify the sentence in regards to the post-release. He merely said, you've got 24 months post-release,
Both the prosecutor and the district court in this case, you would agree, made a mistake of law.
yes,
They didn't know what the law was.
that is correct.
Why does that invalidate a legally imposed sentence just because the judge, if he or she had been enlightened by the prosecutor, might have done something differently?
I think he would have done something differently. We were relying on the pre-sentence investigation that was provided to all parties that indicated that that should be what it was. We were in error in that regard.
So
And
my question is whether a mistake of law negates what is pronounced from the bench. In other words, if it was unintended, does that mean the judge gets overs, even if it's a legal sentence when pronounced?
Excuse me, are you talking about the revocation hearing or the original sentence?
I'm talking about the revocation.
Okay, thank you.
I'm sorry, I forgot what your question was.
We have Judge Worst saying, I will impose the mandated 24-month post-release supervision period. Assuming mandated indicates that he had a mistake of law as to what should be imposed. Why does that mistake, why does that oopsie on the part of the judge and the prosecutor render an otherwise legal sentence illegal? Why does the intent of the judge and what the judge would have done if the judge knew the law render it illegal? Falling back on what my colleague said about the narrow definition of illegal.
Because he didn't change what the post-release was. He left it the same. It wasn't an intentional act on the part of Judge Worst to give the defendant less post-release time. It was his intent to give him less prison time. So we believe that the court should affirm the ruling of the Court of Appeals that it was an illegal sentence.
How does this differ? How does this scenario differ from those cases we've had where a judge pronounced something from the bench and then they've come back later in the day or whenever and says, no, I made a mistake. I really intended, what was in my head, I really intended to impose this. And we said, no, you can't modify once you pronounce. And so unless we're saying that a revocation is not a sentence, I don't see how we distinguish.
The distinction in my mind is that the judge did not make that intention. He didn't want to give an illegal lesser post-release. He believed that that was what it was, and he carried it forward. I think in those other cases that you've discussed and brought up, they changed their mind and wanted to do something different, and that's not what happened in this case. He merely followed what he believed to be the mandated amount of time on post-release.
Which was the original sentence, and then in your view, as I understand it, he was basically reaffirming the original sentence, which I think people have said was an illegal sentence. Is that right?
Correct.
All
Yes. And Judge Frederick was the one that did the motion, and he relied on the statements from Judge Worst at the sentence when he stated no one asked him to reduce the post-release. He was just carrying it forward, and that's what Judge Frederick believed was the situation also, based on his reading of the transcript from the probation violation hearing. Are there any further questions? I'll conclude my argument.
All right, thank you, counsel.
May it please the court. Unless this court has any particular questions, I am prepared to waive my rebuttal argument.
Any more questions? Thank you, counsel. And thank you both for your arguments this morning. Court will take this matter under advisement.